Welcome to Do It for the Case Law for Monday, July 13th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 56 federal appellate opinions across 10 circuits. Our team will cover criminal justice including drug trafficking and firearms cases, civil rights matters involving employment discrimination and Section 1983 claims, Supreme Court and constitutional law developments, business and labor disputes, immigration appeals, and administrative agency reviews. Please subscribe to stay updated on every opinion as it drops. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. We have 17 cases from the 11th through the 9th circuits. The disposition roll-up shows 10 affirmances, 5 dismissals, 1 denial, and 1 reversal with a remand. Leading off in the 8th Circuit, the court reversed and remanded Keshawn Baxter's conviction for possessing a firearm as an unlawful drug user. The panel applied the Bruin test, finding that drug users are part of the people protected by the Second Amendment, which shifted the burden to the government to prove the statute aligns with historical tradition by a preponderance of the evidence rather than beyond a reasonable doubt. Moving to the 9th Circuit, the court affirmed Omar Rodriguez Ramirez's conviction for illegal reentry, holding that he failed to mount a collateral attack against his removal order because he did not show he was deprived of judicial review or that the proceedings were fundamentally unfair. Also in the 9th Circuit, the court denied Gianni Gray's motion to suppress a firearm seized at his home, ruling the evidence admissible under the independent source doctrine because investigators would have sought the warrant regardless of the initial arrest. In the 5th Circuit, the court dismissed 2 appeals for Ivan Vasquez Mosquedela and Rolando Alberto Vindas Abarca after appointed counsel filed Anders briefs finding no non-frivolous issues. The 5th Circuit also affirmed Chemnap Inn's felon in possession conviction and Rafael Perdomo Limas's supervised release conditions, noting the Inn arguments were foreclosed by binding precedent and Perdomo Limas failed to show plain error regarding the sentencing inquiry. Over in the 4th Circuit, Jose Alejandro Belmonte Cardozo was denied relief from a cell phone search at the border, as the court held manual searches are routine and require no suspicion. The court also affirmed Tracy Renard Grant Jr.'s conviction for felon in possession, rejecting challenges to DNA testimony and sufficiency of evidence, while noting his Second Amendment claim is foreclosed. Terry Leon Blankenship's conviction and sentence were upheld in the 4th Circuit after the court found no abuse of discretion regarding evidentiary rulings or sentencing enhancements. In the 11th Circuit, Yafet Martin's career offender enhancement was affirmed. The court held the Sentencing Commission has discretion to include state drug felonies in the definition of a controlled substance offense. Warren Laren Savage's appeal was dismissed under Anders after appointed counsel found no arguable issues of merit. Finally, in the 8th Circuit, Timothy Michael Knopf's appeal was dismissed due to a valid waiver, and Robert Lee Drayton Jr.'s motion to suppress was denied because his erratic driving provided reasonable suspicion for the stop. Back to you, David.
Thanks, James. Let's turn to Aisha for civil rights.
Thanks, David. I have 12 civil rights cases from today's docket. The mix includes 7 affirmances, 1 dismissal, 1 denial, 2 reversals, 1 reversal and remand, and 1 vacatur with remand. We start with the movements. In the 1st Circuit, the court reversed summary judgment in favor of Dartmouth College in an employment discrimination case brought by Amro Foward, finding he presented sufficient evidence that his tenure denial was pretextual. Moving to the 10th Circuit, the court affirmed summary judgment for Walmart on most claims but reversed on a hostile work environment claim. In the 5th Circuit, the court reversed summary judgment for Whole Foods Market in a pregnancy discrimination case involving policy violations. The 9th Circuit also reversed and remanded an attorney's fee denial in a disability access case where the plaintiff obtained injunctive relief. For the remaining routine outcomes, the 1st Circuit affirmed judgments for Brewster Ambulance Service and Dartmouth College on retaliation claims. The 10th Circuit affirmed summary judgment against a Walmart employee on limitations and adverse action grounds. In the 5th Circuit, the court denied qualified immunity to an officer in a Fourth Amendment case but dismissed a frivolous appeal from a plaintiff suing law firms under Section 1983. The 6th Circuit dismissed a retaliation claim for lack of protected activity and affirmed qualified immunity for an officer handling a medical emergency. The 7th Circuit vacated class settlement approval in the Clearview AI consumer privacy litigation due to structural conflicts. Finally, the 9th Circuit affirmed summary judgment against a professor on a retaliation claim. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering constitutional law and habeas cases.
Thanks, David. We have 2 substantive opinions in today's roundup. 1 case was vacated and remanded while 1 conviction was affirmed. First, over in the 11th Circuit, the court addressed Robert Harris's post-judgment motions regarding his habeas petition. The appeals court upheld the district court's denial of requests to amend the petition or for reconsideration, ruling that Harris's arguments were barred by the law of the case doctrine since the issue had already been decided in prior appeals. The court further held that a district court lacks authority to grant leave to amend a habeas petition after final judgment has entered, and that motions under Federal Rule of Civil Procedure 59A cannot be used to relitigate matters. Moving to the Ninth Circuit, Troy Cannon's conviction for sex trafficking by force, fraud, or coercion was affirmed. The appeals court found no abuse of discretion in admitting prior act evidence under Federal Rules of Evidence 404 and 403, noting any error was harmless given the jury instructions and overwhelming proof. Additionally, the court ruled correctly on excluding a hearsay statement because Cannon failed to show he could not compel the witness's attendance or that she would have invoked her Fifth Amendment privilege. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business and civil disputes.
Thanks, David. 15 cases in this Block 10 affirmed, 3 dismissed, 1 vacated and remanded, and 1 reversed and remanded. Starting with the movements that changed the lower court's result, the Seventh Circuit reversed a dismissal in Teva Pharmaceuticals versus Eli Lilly, holding that a settlement agreement without an express end date lasts for a reasonable time under Indiana law, creating a factual question precluding summary judgment on breach of contract claims. The Ninth Circuit vacated and remanded Equine Legal Solutions versus Fireline Farms, finding the district court clearly erred in awarding only $400 when the defendant knew of the copyright infringement after repeated notices, mandating $1,500 instead. Also vacating a preliminary injunction was the Federal Circuit in Ridge Corporation versus Kirk National Lease Company, which ruled the patent holder failed to show likelihood of success or irreparable harm regarding specific claim limitations on flexible door panels. Moving to the Federal Circuit's patent rulings, Google versus Paris Holdings was remanded after the court found the Patent Trial and Appeal Board erred by analyzing prior art references in isolation rather than as a combination for obviousness. The same circuit affirmed 2 other patent outcomes, a non-precedential judgment upholding the Patent Trial and Appeal Board's inter partes review decision in Ecolink versus Roku, and an affirmation of the Court of Federal Claims' dismissal of a bailment contract claim by Shahid against the United States for lack of voluntary delivery of property. In the Ninth Circuit, Brown versus the Los Angeles Department of Water and Power was affirmed because the corporate plaintiff failed to retain counsel as ordered, and the individual shareholder lacked standing to sue for corporate injuries. The Eighth Circuit denied relief in a labor dispute involving the Ironworkers Pension Funds versus Barnhart Crane, upholding summary judgment against the plaintiffs due to the exclusion of an undisclosed expert witness whose testimony was essential to proving damages. In the Seventh Circuit, Gibson versus Chubb National Insurance affirmed partial summary judgment for the insurer, clarifying that Illinois law defines business property broadly to include any activity intended for financial gain, thus limiting coverage to a $25,000 sublimit for contents used in such activities. The Fifth Circuit affirmed 2 dismissals involving pro se litigants with problematic procedural histories. Jeffrey Dennis versus state officials and mortgage entities was dismissed because his claims relied on a flawed interpretation of the Uniform Commercial Code, and Justin Riddle versus X-Corp lost his copyright claim after abandoning arguments and engaging in misconduct that justified dismissal with prejudice. The Fourth Circuit affirmed a permanent injunction against Condice Lucas issued to the Powhatan County School Board, finding no reversible error in the district court's factual findings. Finally, the Tenth Circuit affirmed the dismissal of ERC specialists versus schoolmates for lack of personal jurisdiction, ruling that a single discrete transaction did not create sufficient minimum contacts with Utah to satisfy due process. The 11th Circuit dismissed Marco Cages versus Florida Department of Corrections officials sua sponte because the appeal was filed before a final judgment and challenged an interlocutory order directing an amended complaint. Back to you, David.
Thanks, Maria. Raj has the Immigration and Government Roundup.
Thanks, David. 10 cases on the docket today, 3 affirmed, 1 dismissed, 5 denied, 1 reversed and remanded, and 1 split outcome with a partial remand. Starting in the Eighth Circuit, the court reversed and remanded Jackie Lackey's case against Colonel Eric M. No. The appellate panel found that revoking Lackey's shoreline use permit was arbitrary and capricious under the Administrative Procedure Act. The court held that a settlement agreement signed by Lackey unambiguously resolved all known disputes regarding public lands, rendering extrinsic evidence recommending revocation insufficient to alter the agreement's meaning. In the Ninth Circuit, we see a split outcome in Jose Huazo Marroquin versus Todd Blanche. While the court affirmed the denial of asylum and Convention Against Torture Relief, it remanded the case for further proceedings on withholding of removal. The court found that substantial evidence supported the agency's rejection of proposed social groups like Mexicans perceived as wealthy due to a lack of social distinctiveness in Mexico, but noted that while country conditions suggested a possibility of torture, the evidence did not compel a conclusion that future torture was more likely than not. The Ninth Circuit also issued 5 denials. Brandon Cuellar Cabrera and Yeltsin Magdil Silvestreros had their petitions denied regarding asylum and withholding claims, with the court finding no prejudice from bypassing credible fear interviews in Silvestreros' case. In Chavez versus Blanche, the court found substantial evidence supported the denial of asylum based on worship of Santa Muerte, noting the petitioner offered no proof that such worshippers are targeted for religious harm. Additionally, the Ninth Circuit affirmed the dismissal of Murch versus the United States, ruling the suit was time-barred and failed to exhaust administrative remedies under Section 7433. Moving to the First Circuit, the court affirmed summary judgment for the Centers for Disease Control and Prevention in a case brought by various animal rescue organizations. The panel upheld a federal regulation requiring imported dogs to be at least 6 months old, determining this age requirement falls within the CDC's statutory authority as an inspection measure to prevent communicable diseases like rabies. In the Fifth Circuit, the petition for review was denied in Marari Borona Lira versus Acting Attorney General Todd Wallace Blanche. The court found the Board of Immigration Appeals acted within its discretion in dismissing a motion to reopen removal proceedings because the petitioner failed to show the evidence was previously unavailable and material as required by statute. Finally, in the Seventh Circuit, the court affirmed summary judgment for Infosys Technologies and Brenda Kaler versus the company. The appellate panel held that the district court did not abuse its discretion in excluding expert testimony regarding a name-matching methodology used to identify South Asian individuals, leading to the denial of class certification because the plaintiffs could not satisfy Federal Rule of Civil Procedure 23. Back to you, David.
That wraps up Do It for the Case Law from Monday, July the 13th of 2026. Thank you to James Taylor for covering 17 cases, Aisha Johnson for 12, Michael Reeves for 2, Maria Santos for 15, and Raj Patel for 10. Today's docket featured 3 reversals and remands, which were the most significant outcomes we highlighted. We also saw 29 affirmances and 8 other dispositions, while several appeals were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Please subscribe and follow us for tomorrow's update.